Welcome to the latest Eversheds Sutherland Legal Insights podcast.
I think the first question we tend to get is whether or not employers even need to have the offer letters or employment agreements. And the second is what information is required to be in them or good practice to include in them. Welcome back, everyone. We're excited to have you join us for Conversations Across the Pond, where we'll compare and discuss employment law in the U.S. and Ireland. My name is Bonnie Burke, and I'm an employment lawyer at Eversheds Sutherland, based in the Atlanta, Georgia office. Again, I'm joined today by my colleague, Emma Quinn, who is an Eversheds employment lawyer based in our Dublin, Ireland office. Emma, it's great to see you again.
I know, good to see you too. It's great to be back for episode 3.
I know our audience can listen to this podcast at any time, but we happen to be recording this on a Monday morning, that is, for me. Emma, in a fight between Monday and Sunday, do you know who wins?
No, Bonnie. Who wins?
Sunday, because Monday is a weekday. A weekday. Ba-dum-cha. I'm here all week, people. No, really, all week.
Do you know, I think our listeners are really going to be expecting I was going to say dad jokes, but your mom jokes? Yeah, every episode. But, maybe next episode it's going to be my turn for a joke. But
I think so.
We'll have to wait and see. I don't know how funny I am, but we'll wait and see. I think today's episode is going to be great because, from my perspective, it really focuses on an aspect of Irish law that has certain kind of statutory requirements.
Yeah.
And it'll be really interesting to hear the US side of things. I think, as always, there's so much to talk about, Bonnie.
We absolutely do. Today, we're going to discuss offer letters and employment agreements. Emma, what are a few of the most common questions clients ask you about these documents?
Yeah, I think in Ireland, we actually don't see offer letters that much. So I suppose clients would ask us, do we actually need an offer letter? And in Ireland, it's not a legal requirement to have an offer letter, but it can be really helpful because you can mark your offer or your offer letter as subject to contract. So okay. I suppose while the salary and really high level terms are going to be discussed were included in an offer letter, the employment contract that's going to follow is going to include any additional clauses, and some of those clauses are obviously designed to protect the employer. So if your candidate declines to accept some of the terms and conditions and you're not prepared to negotiate them, you really need to be free to move on to another candidate, which is why, it's just really important to mark that offer letter as, or your offer. It could even be, some people send an offer out in an email, but it's just really important to mark that as subject to contract. So yeah, I suppose in Ireland, like our offer letters are very, very high level. So it would be your salary, your bonus, your benefits. It would just be kind of a really brief outline of the offer. Yeah, but what about you, Bonnie? What are the kind of the most common questions you get around offer letters?
I think the first question we tend to get is whether or not employers even need to have the offer letters or employment agreements. And the second is what information is required to be in them or good practice to include in them. In the U.S., neither an offer letter nor an employment agreement is required by law, though state laws do generally require that certain pieces of information be presented to an employee prior to their first day of work or at the time that they're hired. The information that's required to be presented to them does vary from state to state, and the position for which they have been hired can vary that as well. But typically what we'll see in an offer letter is confirmation of the position that they have been hired for, their start dates, the location of the work, including the full name of the company. We need to identify that employer of record, the address of the company, the agreed upon rate of pay, and whether the position is exempt or non-exempt under the Fair Labor Standards Act and applicable state law. And if it's a non-exempt position, then some discussion about overtime and the frequency of pay. And the frequency of pay should be there even if you're an exempt position. Again, on a state-by-state basis, some employers are required to provide some additional information about things like family medical leave programs that they may have, workers' compensation benefits, and so forth. So typically, when employers decide to provide a written employment offer, that letter will contain these same elements and often a few extra items, including whether a candidate will be working remotely or has the option to work remote, often guidance around remote work will be provided by the employer in policies or sometimes specific agreements if the employer has agreed to a fully remote work position or some arrangement that differs from the rest of the employer's workforce. Emma, how is remote work addressed in Irish agreements?
It sounds like we're quite similar to the US. So I suppose in Ireland, we do find that employers at the moment prefer to keep that kind of contractual place of work as the office, and they might introduce a hybrid working policy or a remote working policy that might form part of your employee handbook. And I suppose we're seeing a lot of employers now engaging virtual employees. So maybe in their contract it'll say that their place of work is their home address or their home office. I won't go into it now because I could be here all day. But it was only about last year. Employees in Ireland now have a statutory right to request a remote working arrangement. So employers have had to grapple with those kinds of requests as well. But it sounds like a US offer letter, can be quite prescriptive compared to how high level an Irish offer letter can be. What else would you see in a US offer letter, Bonnie?
We tend to see some language in offer letters that includes representations from the candidate that they're not subject to a restrictive covenant agreement that would prevent them from accepting this particular job, that they have not during the interview process and will not going forward bring any other company's confidential information into this employer's workplace, because doing so can create liability for that new employer. So good to tell the candidate up front that the employer, don't want that information. What about in Ireland?
Yeah, I suppose that's quite similar to Ireland. Like, I suppose if you have an offer letter, you definitely can include those conditions within an offer letter. But I suppose more commonly, you kind of insert those conditions into an employment contract. So you kind of include language that maybe it's a condition of the offer that they're free from any obligations owed to a third party that might prevent them from starting work or from properly performing their duties. Would there be any other kind of conditions in kind of a US or representations in a US offer letter, Bonnie?
Yeah, we do frequently see employers because employers cannot ask candidates to complete that I-9 form, the immigration form, confirming the employee's identity and authorization to work in the United States until they've accepted an offer of employment. The offer of employment is usually conditioned on the candidate being able to satisfy the I-9 requirements, satisfactorily pass various background checks, and possibly execute other types of employment agreements, such as confidential information protection agreements. What about in Ireland, Emma? Do offer letters tend to include these types of conditions? I think you mentioned some of them already.
Yeah, I suppose we'd always recommend stating that maybe it's a condition of your employment that your references are satisfactory. Maybe as an employer, you want the employee to supply certification that their qualifications are as was stated in their job application. And like similar to the US, we want to make sure that the employee actually has the right to work in Ireland. So it'll always be a condition that they have the necessary immigration permission to work in Ireland. And then one that we don't see as often, but if maybe it's a safety critical role, it's on a construction site or something like that, maybe you want to insert a condition that the employee has to be certified as fit to work following a medical examination before they commence employment. Anything else in the US offer letter, Bonnie? There's a lot in the US offer letter, I think, compared to the bonus and pay in the Irish offer letter. But anything else important, do you think?
No, it's true, because sometimes it takes the place of an employment agreement. I think where employers want to include a more robust description of what's happening, what are the benefits being offered to the employees, we do see a lot in those offer letters. They're still usually only about 2 or 3 pages long, but I think different employers will have some additional terms depending on the role the candidate is being hired to fill, the extensiveness or lack thereof of any company handbooks or policies, and the information required prior to the candidate taking the role. So if the employer intends to provide an employment agreement after the offer letter is likely to contain just those key terms of employment like you described, Emma. But since many employers in the US only use the employment agreements for upper level management and C-suite executives, we may see some of these additional terms included in the offer letter to make it a complete document for the particular employer.
Well, I suppose Your experience with Ireland, Bonnie, is that we always have our 36-page employment contract. So you're very familiar that, while we mightn't have an offer letter, we have our employment contract. And I suppose in Ireland, like a very important part of that employment contract is the probation period. And like we would always recommend to our clients that they include maybe, like, depending on, the nature of the role, but a 3 to 6 month probation period, which essentially is a trial period. So an employer can determine whether an employee is a good fit. Do you have anything similar to that in the US?
Oh, that is a place where our countries differ, Emma. Because most employment in the U.S. is at will, probationary periods work a little differently here. They're not required by law, and they don't provide any additional rights to any party. Though typically an employer will watch new employees a bit closer, provide additional training during that probationary period. But an employer can terminate the employment relationship during probation just the same as it can at any other time in the employment relationship. So some employee benefits may not have become fully available to an employee during the first 30 to 90 days of employment. And there might be some variation in the rights of the employer and employee during the probationary period, if there is one. But those are likely to be contractual. I've seen notice periods be shortened, where they're requiring a notice period to be something other than the typical 2 weeks of notice to be shortened during that probationary period. But tell me a little bit more about the probationary periods under Irish law.
We're very employee friendly here, it seems, compared to the US. But I know I always find the at-will kind of employment thing in the US very interesting. But no, anyway, the probation periods in Ireland, we actually had new regulations come into effect recently that kind of changed the way that the probation periods have to be operated. It was the Transparent and Predictable Working Conditions regulation. So previously, employers in Ireland could, if you had a 6 month notice period, you could extend that. So employers might extend that up to 9 months, or they might, 10, 11 months, but they'd always want to cut it off before an employee accrues unfair dismissal rights when they accrue 12 months service. But now with those new regulations, probation periods can't extend 6 months except on an exceptional basis, and where this is in the best interests of the employee. So lots of change. So we're always kind of encouraging our clients to, make their decisions about an employee's performance, before you hit that 6 month mark. But I suppose probation periods in Ireland, they're only kind of one piece of the Irish employment contract. And we have specific legislation. So it's the Terms of Employment Information Act. So an employer has to provide each new employee with certain core terms within 5 days of starting employment. So, stuff like the salary, the title, the place of work, number of hours that they're reasonably expected to work, etc. But also a written statement of terms within a month of starting employment. And I suppose if most employers will definitely have provided a contract before that month period has expired. So it's really important kind of from our perspective that an employment contract contains all those key terms that are outlined in our Terms of Employment Information Act. And, I suppose from our perspective, and probably from your perspective as well, from a US perspective, Bonnie, a contract has to contain all those kind of sufficient protections around confidentiality, IP, restrictive covenants, although I think we'll definitely touch on some of them in a different podcast. But what about you, Bonnie, in the US? What terms would you usually see in an employment contract when you have one? Because I know they're not very common.
Yeah, the employment agreements in the U.S. generally do include most of the same components and a lot of the same terms that you might see in an offer letter. Some pieces may be part of a separate agreement, such as those protections you were talking about, Emma, the confidential information protections, restrictive covenants, those types of things. And as we've seen the challenges around restrictive covenants, the non-compete provisions over the past year or so, where state laws have been kind of doubling down on them. And then we saw that action by the Federal Trade Commission attempting to ban them. And we may see that come to life again. But where we see those things happening, there's an increased emphasis on those confidential information and IP protections in agreements with employees, really at most levels. But those terms are likely to be either in an employment agreement or in a separate agreement. And because many employers will have an employee handbook, often the terms of the employment agreement can simply refer to the handbook policies or the confidential information agreement if it's a separate document. And we tend to give out separate equity award agreements so that those things can be updated without having to update an employment agreement all the time. So the employment agreements in the US tend to be a little shorter than those in other parts of the world, Emma, particularly Ireland.
Well, I know the employment nerds that we are, Bonnie, we could talk about each clause of an employment contract in extreme detail and in separate podcasts. There's so much to say. And I know down the line, kind of we're looking to go into a bit more detail in future podcasts, particularly kind of restrictive covenants. I think that's going to be another podcast episode soon, but I think we'll leave it there for now. So thank you everyone for listening to episode 3 of Conversations Across the Pond, and we'll be back very soon with episode 4.
This podcast is presented by Evershed Sutherland and is for informational purposes only. The content of this podcast is not intended to constitute legal advice or a recommended course of action in any given situation. This podcast is not intended to be and should not be relied upon by the recipient in making decisions of a legal nature with respect to the issues discussed herein. The listener is encouraged to consult independent legal counsel before making any decision or taking any action concerning the matters discussed in the podcast. This podcast does not create an attorney-client relationship between Evershed Sutherland and the listener.